please.
Thank you, Mr. Speaker. While there is much in C-75 that I support, particularly getting rid of peremptory challenges in choosing juries, I'm very disturbed by changes that are proposed to Section 657 of the Criminal Code. I can't imagine how this got so far, and I hope the honourable member knows I'm referring to changes that will mean that a police officer need not be on the witness stand available to a defense attorney, a defense lawyer to cross-examine that police officer, that they could submit an affidavit or previously submitted evidence. The credibility of a police officer on the stand very often is the difference between an innocent person going to jail or not. And this has been universally condemned by the criminal law bar. There was no consultation on this. So is it a mistake? Can it be changed in committee? I asked the honourable member, and I hope the answer is that this was a mistake.
Parliamentary Secretary.
Well, I want to thank my colleague for her thoughtful comments on this particular provision of the bill, and I want to assure her that we have been listening very closely to the Criminal Lawyers Association as well as other stakeholders who have given us input on this particular provision. I also want to assure her that the objective of this provision, along with a suite of other measures, is to ensure that our courts are allowed the proper flexibility to streamline hearings so that we are not quibbling over non-contentious, immaterial facts. And, Mr. Speaker, as somebody who practiced in the criminal justice system, we see far too much of this bad judgment exercised. And it's not just about revising this bill. It's about a change in the culture of complacency, which the Supreme Court of Canada has encouraged all of us to look very closely at. And I look forward to further discussions with my honourable colleague as well as others on this particular provision. Thank you.